thanks to the Data Retention Directive. And now we also have private entities which are basically collecting every piece of information we are accessing through tracking of web habits. And again, this touches the freedom to knowledge. And as Jan also mentioned, a lot of the IPR enforcement debate also goes about privacy of users. To give another example where it all comes together again, there already have been court cases about IPR enforcement in Sweden where rights holders demanded data retained by telcos, because they have to comply with data retention, to hand over contact details of people using peer-to-peer culture sharing programs. And again, that also means that you cannot say we leave IPR debates alone and we're going to focus on privacy, or the other way around. It all touches each other. And if I may also give another little piece of advice, and then more on the IPR area, is I think it's worthwhile to decouple the issue of remuneration of artists from the issue of what is a proper copyright regime, a proper patent regime. I'm not even sure whether patent should be there altogether, and trademarks and so on. Because the debate on IPR is poisoned all the time by entities claiming to protect artists who at the same time abuse their contractual negotiation position against artists to actually get to stiff the artists. If we're going to give more concrete advice, I think in the short term there's a window of political opportunity to improve the IPR debate by reforming copyright contracts between authors and intermediaries, such as the publishers and so on, and the record companies. But that's an area where there are easy gains. I also think that thanks to ACTA, it has become clearly visible that IPR regimes have gone completely overboard. I think there's political capital waiting to be spent or wasted on stopping further extensions and maximization of all those IPR regimes. I think IPRED is coming alongside. The Commission already is kind of aiming to introduce a new IPR trade secrets for the sake of harmonization. Well, there's only one member state in Europe that does have trade secrets, that's Sweden. And I love the Swedes, but I don't think we should emulate the Swedes in this respect. To have another layer of opacity added on the already growing opacity of governments and private entities, while at the same time the citizens are sitting more and more naked and being completely transparent in front of those private and public entities together. So I will leave it at that for right now. Thank you.
Thank you very much, Walter. And I would like to perhaps discuss some topics which are still on the table. You talked about the question also of the freedom of information. So freedom of information, I think, is something which generally is what the whole thing is about, because the World Wide Web, the internet environment, brought the huge possibility to exchange information with a sender and a receiver. It was different to the television, where I just consume what was sent to the television. Now I can exchange information also, so my freedom of information is far more individual, and freedom of expression also. And you mentioned the question of net neutrality also, and in connection with all the different examples you gave on companies, I mean, doing services which are involving our privacy, and also which are giving us perhaps only a limited view of what is the internet about and so on. My question would really be, do we need something like an internet bill of rights, or something like fundamental rights, or rules for the digital environment? or do we need to adjust or just clarify the way of dealing with fundamental rights and freedoms in the digital environment? Or do we even need an internet regulatory body or something like this? I would like to give this question in a second round with you, and I don't know if you want to start, Benjamin.
Yeah, I bounce on the do we need an internet regulatory body, because the internet was created by mostly by technicians, because it was the fact that they wanted to interconnect networks that didn't talk together before. And there's been a lot of discussion on the regulation of the internet lately, those decades. And what we can see is that there is not one regulation of the internet, there is some regulation. For example, the protocol we are using. Technically, internet is a very technical thing. We are using many protocols, and they are discussed by technicians and engineers in a regulatory body called the IETF, which is very open. Anybody can participate. I did a few years ago. I was not involved at all in any specific body talking on those topics, but I was concerned by one particular protocol, so I participated in one group. And it's very open, and the norm they are publishing are open too. It's called the RFC, the Request for Comments. And there is some very specific rule saying you should allow anybody to implement that protocol freely, etc. There's very strict rules on the openness of those protocols, and that made internet possible. Because those protocols, those technical rules were open, it's made internet possible, because anybody anywhere in the world could start a network operator. And that's why any country, all the countries of the world started to implement the internet protocol, because they could do it freely with their own software or hardware. And now we got the internet we know today. And that technical part is still working as it was working 20 years ago. So the technical and engineers part of the internet is working fluently and quite almost flawlessly since the beginning. So regarding the technical regulation, I don't think we need some new things that could frighten non-technical guys inside the team. The groups. But yes, there is also that content and pipes regulation question, which is quite important. The problem we have is that, as you say, the internet gives the citizens the power to use for real their freedom of expression. I mean, 20 years ago, if you wanted to, or 30 years ago, it's very near, I was already born. 30 years ago, if you wanted to talk to many people, you were, in your country or small city, you have to find a radio or a TV. They were very rare, and they have a scarce time frame and not many channels. So it was very hard for people to express their opinion, to express themselves, and to exchange. Even you got a phone, but you can't phone with many people at the same time. If you look at the internet as of today, we can use for real our freedom of expression. We often use that comparison with when the book was born. When Gutenberg invented the mobile character and invented the printed book, he allowed people to read books. Not to write them, to read them, because it allowed many copies of the same book. And with the invention of the internet, now people can write books. They can exchange, they can communicate a lot more. And so the freedom of expression is crucial in the internet. The problem is that as of today, the network operators are considering their customer as eyeballs. I use that term because it's the term they use on a daily basis. Their customers are eyeballs. Eyeball is this round white part of the eye. It's very interesting. We are also hands. We can write. We are also mouth. We can speak. And that's very important to us, because if there has, I mean, so the internet is yes, we are watching a lot of video, or watching as watcher a lot of things on the internet, but we are also participating. And we are participating on public things. We publish things so that anybody can see it, but we are also publishing things on private, exchanging emails with our girlfriend or boyfriend, exchanging information with our doctor or banker. So it's a mix of public, published, and private, and sometimes even intimate information. And that's bringing us to the topic of network neutrality. On all those types, there is private and public and published data. We cannot say, by looking at what's going through a pipe, if it's legal, illegal, public, private, or whatsoever. So if we can't say, it has to be protected. I mean, that's what is the network neutrality. You can't look at the pipe. That's personal data, that's all. And so that's very important to us. I don't know how I say it.
Very good. That leads me to a question which I would like to give then further to Christiana, because the question which comes up at that point, of course, is always, okay, but what are you doing then about the question that there's, of course, also illegal content around, and that there's also criminal people conducting things in the internet. And as we heard how unproportional the way of just collecting everything by data retention is, and how that also is not leading to a very possible law enforcement, as we cannot decide from the outset.
Excuse me, Jan, if I may. There's almost no such thing as illegal data. I mean, for real. That's one of the crucial points we found when we deal with the music industry and the film industry. When they were talking about people exchanging films or music, they were talking about illegal data. It's not illegal at all. The usage those people make of those data could be considered an infringement of a copyright, blah, 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 but it's not illegal in itself. A film file is not illegal. Yes, there could be illegal data like the usual child porn and so on, but it's illegal even if it's not on the internet. I mean, and we already had laws, very strong laws against that, and specific service in the police officers and so on. So the term illegal data is very cumbersome for us, because it's most of the time turned around to talk about infringement of copyright and so on. So, but yes, regarding data retention issue, this one is critical too.
Yeah. And I think it's perhaps a bit too easy to say there's no illegal content, but because of course there could be, and we shouldn't say there's no criminal activity over the or in the digital environment. But I would like to ask you, Christiana. I mean, what is the alternative, and what is the positive agenda also on this, the law enforcement side? So how are we building up a society which is not as intrusive and as dangerous also to freedom of expression and freedom of information?
I think that the reason that there have been so many initiatives on a rolling basis, especially in terms of my area, I'm mostly looking at the Commission. So in Europe, there's been a flood, really, of initiatives that have been trying to deal with these issues of illegality. But I think part of the reason for this is, in part, is fear, a fear of not being secure, so emotional, and in part, it's driven. Legislators, let's just say, the executive is motivated. Powerfully motivated by very powerful interests, and it includes the most, there's the copyright industry, so the entertainment and music industry, they're combined with the pharmaceutical industry, and then you have, of course, the security industry. And these all together, you can imagine what kind of force this would make in terms of lobbying. So that's just one reason. But the problem is that a lot of these initiatives are not based on the rule of law. They don't follow the treaty law, the charter, a lot of the time, quite a lot of the time. And this is what a lot of these measures have in common. So it seems like they're being pushed ahead very quickly, much too quickly, and not well considered. And so the Data Retention Directive is a good example of that, because it's flawed in so many ways that it doesn't achieve its purpose. No other less invasive measures were looked into before this was adopted. There weren't even any risk assessments done, in fact, before 2006. And even now, during the evaluation, these again are not being looked into. And at the same time, I think the German minister just had suggested to the Commissioner Malmström the quick freeze option, where you have authorities have they can access data under a court order based on probable cause. So this is the kind of thing that appears reasonable, but these issues are completely overlooked a lot of the time, and it will lead to all sorts of counter effects. And again, in the case of the data retention, recently the Max Planck Institute published a study that indicated that there was no measurable effect in terms of crime clearance rate in Germany and a few other countries when the data retention directive was in place and when it wasn't. And part of the reason for this, it's plausible anyway, that there's a lot, because people know that their communications are monitored, and they obviously find different ways to communicate or to non-electronic means. So, or else they go to e-cafes or use wireless networks and anonymous services. So again, the directive doesn't really mean very much anymore. The actual criminals that would be paying attention to these issues are avoiding the grid, and as a result, police authorities are less effective. They can't, when they're not working on targeted strategies, that it won't lead to better results. And I just want to quickly go back to your other question, because I have very strong opinions about rights and expanding rights. I don't believe I'm not a great fan of making many more things rights, even in new environments where obviously there are different contexts, different solutions needed. And the reason for that is, I guess it's just a very libertarian perspective. I think that if society is able to protect through a sound constitution the rights like freedom of expression, freedom of information, some of the very core civil and human rights, then everything else that's a society feels that it needs can be fought for through the legislative process or what have you. But if everything becomes a right, like for example anonymity, many people think that it should be right, and I believe that in principle it should be a right, but I don't really like the idea of pushing for that to make it a right, because then the whole idea of a right loses its weight and effectiveness as a result. And I think that's kind of the direction we're heading into in this century, that in 50 years rights may be meaningless, because also, of course, the term is abused and used and invoked by almost any politician for things that really shouldn't be considered. So that's from my constitutional law training. This is something that I've learned, that a right is a specific thing with a specific purpose, and you have to have a certain understanding of the context before considering whether rights should be expanded. And about the internet governance, just a few things. You're probably aware of the ITU meeting in December, or maybe you are. It's a very hot topic. It's the International Telecommunications Union that is meeting in December after, I think, 25 years. And so this is a agency of the UN, and there's going to be a big decision made at this meeting in December about whether internet is going to remain free or whether it's going to be monitored, in a nutshell. And I think it's very telling that so far the countries that are very much pushing monitoring are Russia, China, and Arab states. So, and also this particular union does not at all include any civil society or expert. It's really heads of states that are going to be deciding these issues. So the implications, you can imagine, are enormous.
Thank you, Christiana, and that brings me also to another picture, because I mean, as you too now try to formulate it, it's a problem that throughout the last years the internet was to be seen as a black box where everybody is fearing that I don't know, crime is just growing and people are just exchanging illegal data and so on. So I hear also your pledge to say clearly it's not a black box, it's a part of our all-day lives, and it has to be dealt also, or we have to deal with the problems with our rights which we have in our analog environment. And Walter, I would like to ask you a bit finally, if we talk about the way how we do that, then it's obvious. I mean, if we talk about having already rights, then we are talking about having all the same rights. But for example, in Europe, every state still has different law, especially when it comes to fundamental rights and or to rule of law principles and to procedures and so on. My question is really, how are we facing these differences? Because governments also in recent years tend to say, okay, then we enforce our law in the internet also, so that leads to a different application and sometimes also to censorship. For example, if you enter a website in a different member state, you sometimes get different answers because of different copyright laws, because of different data protection laws or whatever. And my question would be, once again, a bit the European dimension. How do you think we will solve these problems? And do you also think we need, for example, European rules in these areas, and perhaps also someday global rules? But there we see, of course, the challenge in the ITU that governments are just doing their policy there. So what do you think about these challenges?
Well, in terms of maintaining, defending civil liberties in on a global medium, at least a cross-border medium like the internet, at the somewhat longer term, we already do have lots of harmonization through the European Charter of Human Rights. The country I'm from, the Netherlands, doesn't even have a proper constitutional court. It's kind of a developed nation in that respect, or worse than most developed nations, let's speak. I think only the English are worse off than we are because they don't even have a constitution, but let's leave it at that. But thanks to the fact that treaties can override national law, this allows for judicial review of laws, for example, touching freedom of expression online. So I'm very glad with the fact that we do have a European Charter for Human Rights and a European Court for Human Rights in Strasbourg in that respect. But you're quite right, the fragmentation and the lack of harmonization are also kind of holding us back. I'm quite sure that all the moaning and grinding and tearing of the content dinosaurs will be over as soon as we get to a properly harmonized European market for culture online. Because every time and again, and I think that's also one of the takeaways, that policy making should be evident, but all the evidence again and again is pointing that as soon as we are talking about what Benjamin rightly said, not necessarily illegal content, but let me say sharing of culture that upsets outdated and old-fashioned paradigms for business models, as soon as there is a proper supply of this culture, all of a sudden this, by some unwanted culture sharing, drops dramatically. And I think the upcoming collective rights directive, I'm in no way a fan of collecting societies, but I think the current proposals by the Commission to at least harmonize that a bit and to introduce one-stop shopping for levies, which is a can of worms in its own, but the fact that there will be one-stop shopping might improve the situation dramatically. So yes, there absolutely is a massive European role, but there already is. If you operate in the area of law and the digital environment, over 90% of legislation comes from Brussels anyway. Which brings me to a final point, and then I'll cede my again. Is one of the things I think is sorely lacking is proper media exposure of what's going on in Brussels. I mean, on Dutch television, you have this weekly magazine called Den Haag Vandaag, which roughly translates as The Hague Today, but it's almost daily, but I hardly ever watch television anymore, just for old people. But there's no such thing as Brussels Today. And I don't think that's the case in France, Germany, or any of the other European Union member states. Merely the fact that most national media only report on major decisions in Brussels after the fact, such as the passenger name records directive, or treaty it is. That only became news after it was basically, and then the news is, yes, Brussels signed away our rights of privacy to the US. Yes, thank you very much for informing about something. We could have mobilized citizens if you had taken the bloody effort to report about it about a year ago. And on that note,
thank you very much, Walter. And as we are now at the final, I would like to ask you in one last minute for your 1, 2, 3 points which should be followed by the European Green parties in the next election campaigns, especially in the European Parliament campaign. So if you have points which you really think we should take up, this is the time to mention them, and but please make sure that we are already at the final. So I don't know if you want to start, Christiana?
Okay, well, one idea that I have that I mentioned at a stakeholders meeting a few months ago that was trying to find a solution to how to bring in more ethical perspective in decisions that the Commission is making. I suggested that they monitor the decision-making process of the Commission to simply make sure that they're actually working within the democratic process, because with a lot of the legislative initiatives I've been following over the last 3 years, quite a few of them, especially related to self-regulation and blocking, are done in a I don't know how to put this politely. Well, they're outside of the view of the Parliament, for example, and certainly the public. So this is something that I would love to see, for example, maybe the Fundamental Rights Agency take on. And it sounds a little bit harsh, but I really believe that there's a need for that, along with more transparency. The documents that we're not able to receive to look at, to see how the evaluation process on the data retention directive is going. I really have to question the basis on which we couldn't receive these. They said that there was a risk of interfering with the decision-making process, but this is an evaluation process, and I really can't help but wonder why the public is not able to be privy to how this is going along. So these two things, in terms of the data retention directive, if you're interested, I would certainly be willing to inspire you with parliamentary questions. And for example, with the head of the evaluation process right now, at a meeting a month ago, I asked him if the Commission would launch a fact-finding mission to look at the abuses as a result of the directive, because so far the Commission refuses to acknowledge there's been abuse, even though we've been feeding them examples, but officially there's been no abuse. And he said that he would consider it, and that's something I would love to see that pursued.
Thank you very much. Benjamin.
Yeah, I will insist on Christiana asking for transparency. ACTA was negotiated in closed door. This cannot happen. I mean, even the Parliament, the European Parliament, if you remember well, voted a resolution saying we want to read, we, members of the European Parliament, want to read that that text we're negotiating. That's crucially important. We need more transparency in the European negotiation of whatsoever, even outside the digital rights topics. And another topic which is very important to us as of now, ACTA is dead. There is a massive citizenship awareness all over Europe around those topics. So take the stream and follow the stream, and maybe we could try to push forward that kind of positive agenda on a stronger and a stronger intellectual property rights reform. I remember you are on now. It's the positive agenda we started to discuss with other NGO in Europe is on positive.co/co-ment, like a comment with a dash in the middle, .org. positive.co-ment.org. You got the text we started to think about a few days ago in Barcelona at the Free Culture Forum. Read it, it's very inspiring. And we talk about legalization of non-profits, sharing of culture between citizens. It's the third point, which is crucially important in our opinion. Thank you.
Thank you very much, Walter.
Okay, yes, I have to. First of all, keep on doing what you are doing, because the Greens have been great allies in this field, to such an extent that I'm even fearful that we're reaching the point that when we bring up digital rights, that the EPP people will think, oh, you have those bloody hippies from the Greens again. And, sorry? Which, well, maybe the Greens don't mind, but I don't mind, because the EPP are just simply too large to ignore. So we have to keep on framing these issues in ways we can reach across aisles, because these are not necessarily left and right issues. I mean, even the Front National votes consistently good on digital rights, much better than most other parties. I'm definitely not a fan of Front National, I must add. On data protection, there are two major things that absolutely have to be addressed. One, make sure that the regulation, and if possible, the directive on the public sector part gets teeth. The reason why we're in this bloody mess to begin with, and we're barreling headlong into a surveillance economy, is there's hardly a downside risk to collection, processing of personal data. The costs of surveillance, storing, and transmitting all the data are still dropping dramatically. And there is no, every time I have a discussion with, for example, entrepreneurs, and then I tell them you're doing such and such, and that's such a thing that is probably kind of difficult to reconcile with the current data protection directive. Most of them actually want to adhere to the rules. The private sector actually is more willing to adhere to the rules than the public sector generally is. But nonetheless they ask, and what is the risk I run if I do it wrong? And And then I have to say, well, currently the DPA can fine you 4,500 euros, and then they shrug their shoulders and say, well, why bother? So that's one point. The other point on data protection is the transatlantic that I mentioned. This is becoming a point of contention between the EU and the US, and I think we should actually risk a trade war with the USA on this subject. That's a bit of a radical statement, I know, even among the Greens. But other than that, we already currently have our right to privacy kind of leaking away in the direction of the USA, and I don't think the current movements towards to even more transatlantic sharing is a good thing. We must put a stop to that. And I think I've taken enough of your precious time already with that.
We thank you very much for taking this time and for having the time with us in this debate. We are at the end of it, and I would thank also everyone who listened to all the remarks and who took part in this debate. I think we will follow up this topic. We have a draft working paper which we are still working on with our Digital Rights Working Group and the European Green Party, and we hope to adopt a very comprehensive position paper on the next council, which we have in April or May next year. And for you, I would very much like to thank you by giving you such a bag from the Greens with some nice present in. And for all the rest, thank you. Thank you very much. For all the rest, or for all those who would like to now get to the nice part of the evening, so the dinner and the party with live music, there will be